What is automatic restraining order? In family law cases, whenever a divorce is filed, the petitioner has to file an FL 1110 form. And on page 2, it says on top, automatic restraining order. And it goes to explain every single step what it means. Specifically, basically keeping status quo. Don't move money from separate property to a different account. Don't sell a home. It says do not remove a child or children out of state once divorce is filed. So basically, when you file, that's applicable to you. When you serve the other side, it's applicable to them because the court has jurisdiction over them. So they receive the paperwork. They know. How do you serve them? By hiring a process server, a third party professional, or anyone over 18 personally delivering them the petition package, meaning FL 100, FL 110, or whatever local form. In San Francisco, it's 11.17 ADR form. So once the other side is served, they are under automatic restraining order. Now, what is the consequence if automatic restraining order is violated? There are two exceptions. When restraining order is not applicable is when money is used to pay living expenses and attorney's fees. Now, tricky topic. What if, in order to pay for attorney's fees, you need to take a loan on a home, let's say HELOC, that would encumber the real estate? Well, that's a gray area, right? It's not automatically violation, but there's no clear answer to this question. So the way I would handle it, emailing opposing side and ask for consent. And usually what happens, they say, of course, take your attorney's fees. I want the same amount when you take the loan. So then it becomes more of a question, do the client will take then a credit card loan instead? Because it doesn't encumber anything. It doesn't create potential violation of automatic restraining orders. Now, the consequence of violation of an order is the same as any consequence when someone violates an order. Contempt, sanctions, 271 Family Code sections. Contempt or one strike could be 5 days in jail. Have I seen anyone being put in jail by the judge over a decade in my experience? No, never. Even I have seen where opposing side violated numerous court orders 13 times. No sanctions. There was a trial. This client was self-represented and she filed for contempt, and it was a trial for 4 hours. And she literally won on every single count, and there were no consequences for the other side. So I'm not saying that it's always like that. That's an extreme case. I've seen judges order sanctions, $5,000, but I haven't seen jail before. It doesn't mean that it's not going to happen. I haven't seen it. I haven't heard of it from other attorneys. So a typical consequence would be sanctions, monetary sanction, or transfer money back, or freeze the money. And that's all I have seen. I haven't seen where the judge would say, oh, you transferred $1 million back. Now you have to forfeit that $1 million and give it to the other side. For example, in Rossi case where Court of Appeal decided because wife didn't disclose her lottery winning, although it would have been her separate property, the judge awarded 1101G Family Code section sanctions against wife and asked her to, basically ordered her to transfer the entire amount to husband by her violating the disclosure part. So that was the extremist case I've ever read in cases of appeal, but in my practice, that's not what happens. I created this book to help you understand the divorce process without getting lost or without getting a heart attack. You can buy it on Amazon in all formats, including audio format. How to handle this kind of situation. So the best way to handle it is there is an extraordinary expense if you're planning to sell your stocks to pay living expenses. Provide the other side explanation, accounting, that's what you're doing. If it's extraordinary, sometimes you have to pay taxes, so then you would explain that as well. Consent. Written consent is required at least 5 days before doing this transaction if you are transferring money from separate money to another account. And if the other side doesn't give you consent, you would need to get it from the court, which will delay things. but it's possible. So I have seen cases where a wife would sell her separate property home. We would ask her to explain why she would do it in the middle of a divorce proceeding, and she wouldn't give us an answer. We would file a motion for violation of ATROs, and the judge wouldn't do anything about it. So it's a tricky topic, because on one hand we have this ATRO, on the other hand I have seen variety of things undecided, basically, where it's a gray area, it's case by case. But the guideline, we follow the guideline. We do by the book how the automatic restraining order is designed, and then there is this gray area. So I wished I would give you a better guidance about automatic restraining orders. The one thing that is really strict is taking a child out of California without that parent consent. That's the big no. So that I have seen being sanctioned, and a parent would lose custody, completely legal physical custody, when and if the automatic restraining order was violated. So that's the big one. I would suggest to follow the rule, and then in doubt, reach out to the other side and ask for consent. If no, in doubt, would get a court order, just to avoid unnecessary sanctions. I hope that was helpful. I'll see you in my next video. Bye.